The guarantee of equal protection applies against the substantive as well as procedural law. The decision making process should be transparent, fair, and open. The procedure for distribution of state allotments must be transparent, just, fair, and arbitrary. Not non-transparent promotes nepotism and arbitrariness. The role of model for the governance decision taken therefore should manifest equality, fair play, and justice. The cardinal principle of governance in a civilized society based on the rule of law not only be based of transparency but must create impression that the decision making has motived on the consideration of probability. Government has to rise above the nexus of wastage to withstand wasted of interest of nepotism, issue window dressing. The act of governance has the ability to stand the test of judicious and impartiality, avoid the arbitrary or capricious action. Hence, the discretion vested by the statute is to be exercised fairly and judicially, not only arbitrarily, but subject to requirement of law. In the absence of rule, inaction of the government is required to be fair and reasonable. From the standpoint of the latter, it means that all litigants who are similarly situated are able to avail themselves of the same procedural right for the relief and for the defense without discrimination. The discrimination presupposes the classification of similarly situated person into the different group without any reasonable basis for extending similar benefits for treatment. Of course, if the differences are of minor or unsubstantial character which have not prejudiced the interest of person or a person affected, there would not be a denial of equal protection against again a procedural difference from that laid by the ordinary law can be prescribed for a particular class of a person if discrimination is based upon the reasonable classification having regard to the object which the legislation has in a view and policy underlying it. Thus, in a law which is provides for the extermination of undesirable person who are like to jeopardize the peace of locality, it is not a reasonable discrimination to provide that the suspected person shall have no right to cross-examine the witness who depose against him. For the every object of legislation which is an extraordinary one would be defeated if such a right were given to the suspected person. In the reference of the Special Court Bill 1978, the Supreme Court has held that the setting up a special court for the expeditious trial of the offences committed during the emergency period from 25th June of 1975 to 27 March 1977, high public official in view of congestion into the work in the ordinary criminal court and in view of need for the speedy termination of such prosecution in the interest of functioning of democracy under the Constitution of India. It is a reasonable classification, but the include in the bill any offence committed during any period prior of the proclamation of emergency in June 1975 was unconstitutional in as much as such classification has the no reasonable nexus with the object of the bill. The provision under Article 14 of the Constitution would be violated if there is arbitrary discrimination among the educational institutions similarly situated. The procedural which come in the way of party in getting fair trial would be violative of Article 14. Article 14 of Constitution should be stretched too far, otherwise it will make a functioning of the administration impossible. The guarantee of equal protection include absence of any arbitrary discrimination by law themselves or in the matter of administration. Thus, even where a statute itself is not discriminatory, but the public official entrusted with the duty of carrying into the operation applies it against an individual, not for the purpose of act the intentionally for the purpose of injuring him. The latter may have the Executive Act annulled by the court on the ground of contravention of the guarantee of equal protection. Of course, it is the aggrieved individual to establish beyond the doubt that is law applied against him by the public authority with an evil eye and an equal hand. Wide discretionary power conferred by the statute of any authority must be exercised reasonably in furtherance of public policy and for the public good and the public cause. The authority must record reason for the said exercise of power even if the statute does not expressly rejoin upon the authority to do so. The action of state must satisfy of the principle of requirement of Article 14, treating the person similarly situated equally in grant of equal protection of them. Reasonableness and fairness in the heart of soul. Article 14, in short, Article 14 hits arbitrariness of state action in any form. In act which is discriminating liable to the label as arbitrariness in the making of a order by authority can manifest itself in the different form. Non-application of mind by a authority making the order in one of them. Application of mind is best demonstration by disclosure of mind by the authority making the order, and disclosure is best done by recording the reason and lead by authority to pass the order. The court will not interfere in the policy decision of the government unless the government action is arbitrary or individually discriminatory. The government policy is not subject to judicial review unless it is a demonstrably arbitrary, capricious, irrational, discriminatory, or violative constitutional or statutory provision. To wrong do not make a right. To wrong do not make a right. A party cannot claim that since something wrong has been done, direction should be given to do another wrong. It would not be setting a wrong right, but would be perpetrating another wrong. In such matter, there is no discrimination involved. The concept of equal treatment presupposes the existence of similar legal foothold, does not countenance repetition of wrong action to bring forth wrong on a par. It is the duty of state to allay fear of citizens regarding discrimination and arbitrariness. However, the protective discrimination in favor of SC/ST in a part of constitutional scheme, a social economic justice to integrate them into the national mainstream so as to establish an integrated social order with equal dignity of a person. There are two dimensions of Article 14 in its application to the legislation are rendering the legislation invalid. Now well recognized with are discrimination based of the imperishable or invalid classification. Excessive delegation of power, conferment of uncanalized and unguided powers on executive, whether in the form of delegated legislation or by way of conferment of authority to pass administrative order. If such the conferment is without any guidance, control or check, it is a violative of Article 14 of Constitution. In Board of Control the Cricket in India and Netaji Cricket Club, the Supreme Court, while considering the role, nature of function being discharged by the BCCI, held the Board of Control over the sports of cricket was deep and pervasive, and that is exercise enormous public function and corruption in the sports bodies. Deep and pervasive that they exercise enormous public function, which is made obligatory for to board to follow doctrine of fairness and good faith. The BCCI is not a state within the meaning of Article 20, Article 12, as the board was not created by any statute nor a part of share capital held by the government. The nature of duties and function which is the BCCI perform with regularity and control the game to the exclusion of all others. It is formulate rules, regulation, norms and standard covering all aspects of game. They enjoy the power of choosing the member of national team and empires. In exercise the power of disqualifying players, which may be times put an end to the sporting career of a person and spend crore of rupees on building and maintaining infrastructure like India, like stadium, running of cricket academy, supporting state association. It frames pension schemes and incurs expenditure on coaches, trainer. It sell, broadcast and telecast right and collect the admission fee venues where the matches are played. It is all the activities are undertaken which the tacit concurrence of the state government and the government of India, who are not only fully aware but supportive of the activities on the board. The state has not chosen to bring any law or taken any other step that would either deprive or dilute the board of monopoly in the field of cricket. On the contrary, the government of India have allowed the board to select the national team, which is then recognized by all concerned and followed by the entire nation, including Laurel Home. Those distinguish themselves in the international arena are Padma Bhushan and Padma Shri, apart from sporting award instituted by the government. Any organization or any entity that has such pervasive control over the game and its affair, such power as can make dreams end up the smoke or the come true, cannot be true to be said on undertaking any private activity. The function of board are clearly public function, and the entity discharging the same of the answerable of the standard generally applicable in judicial review of the state action. Therefore, the BCCI may not be state under the Article 12 of the Constitution, but the certainly amenable to the writ jurisdiction under Article 2 to 6 of the Constitution of India. Relation between Article 14 to 16. As the Supreme Court has observed, Article 14 to 16 have together inserted the principle of equality and absence of discrimination, while the principle of generally stated the Article 14 as extent of all persons, citizen or alien. Article 15-16 deal with the particular aspect of that, the equality. Thus, Article 15 available to the citizen only, and it prohibits discrimination against any citizen in any matter at the disposal of the state or any of specified ground, namely religion, race, caste, sex, or place of birth. Article 16 is also confined to the citizen but restricted to one aspect of public discrimination, namely employment under the state. In the matter not coming under Article 15 and 16, there is any discrimination, the validity of can be challenged under the general provision in Article 14. In just state a particular aspect of the equality guaranteed by Article 14 in prohibition against the discrimination contained in Article 15 of the Constitution, which run thus. Article 15 prohibition of the discrimination ground of religion, race, caste, sex, birth, place of birth. A state shall be discriminated against any citizen on grounds of only religion, race, caste, sex, place of birth, or any other them. No citizen shall on the ground of the religion, race, caste, sex, place of birth, or any them of subject any disability, liability, restriction on condition that regard to access to shop, public restaurant, hotel, place of public entertainments, the use of well tank, bathing ghats, roads, palace of public resort maintained wholly and partly out of the state fund dedicated to the use of general public. Nothing in the article shall be prevent to the state from making any special provision of women and children. Nothing in this article of the clause 2, Article 29, which shall prevent the state from the making any special provision for the advancement of any socially and educationally backward classes of the citizen of the scheduled caste and the scheduled tribes. Nothing in the article of subclause G of clause 1 of Article 19 shall be prevent of state from making any special provision by law for the advancement of the any socially educationally backward classes of citizen for the scheduled caste or the scheduled tribe is on for such the special provision related to the admission of educational institute, including private educational institute, whether the aided or non-aided, unaided by the state, other than the minority educational institute referred to the clause 1 of Article 30. Article 15 of the Constitution has been amended by the Constitution 103 third 103rd Amendment Act 2019. The 2019 Amendment Act added new clause of 6 to provide the special provision for the advancement of economically weaker section of citizens, including special provision relating to their admission to the educational institute, including private education institute, whether the aided or non-aided by the state. Other than the minority education institute referred to a clause 1 of Article 30, a reservation provided under newly added clause 6 would be addition to the existing reservation subject to maximum of 10% of the total seat of each category. Clause 6 of Article 15 provides as follows: nothing in the article or subclause G of clause 1 of Article 19 or clause 2 Article 29 shall prevent the state can making any special provision for the advancement of any economically weaker section of citizen other than the classes mentioned in clause 4 and 5, and any special provision for the advancement of any economically weaker section of the citizen other than the classes of mentioned clause 4 and 5 so far the special provision related to their admission to the educational institute, including private educational institute, whether aided or unaided by the state. Other than the minority educational institutional referred to in clause 1st of Article 30, which is case of reservation, would be addition to the existing reservation subject to maximum 10% the total seat of category. Explanation: for the purpose of this Article 16, economically weaker section shall be such as the many notified by the state from the time to time on the basis of family income and other indicator of economic disadvantage. The scope of article very wide. While the provision of clause 1 level against such state action, the provision of clause 2 is the level against the individual as well.